Hello, everyone, and welcome to your online cafe. For some reason, whenever I'm on this platform, especially your online cafe, I'm just so relaxed. Maybe because it's on a Sunday and Sunday does that to people. I don't know. Or maybe because, it's your platform, your topic. So, the pressure is a bit less. Whatever the case might be, I'm happy to be here. Having said that, I'm pretty sure today's topic must have picked a lot of interest, a bit of surprise, a bit of raised eyebrows, a bit of excitement, and a lot of reactions. But just let me clarify that today's conversation is not about any particular viewpoint or opinion. It's completely based on facts. As today we have with us very renowned senior Supreme Court advocate who was actually a part of the processing itself. So we will hear all the facts directly out of the court and some inside story. So we'll talk about the history of the dispute, the decision itself, how it came about, and so forth. So let me bring in my guest, and then we can go ahead with the show. Hi, Jaideep. Welcome to the show.
Hi, Sonal.
I must say
How
you
are
have
you
picked
doing?
up you have picked up a very very current and a very relevant topic because there is so much buzz around this particular issue because thanks to RPM we did our laying of the foundation on the 5th of August. But like I said, it's all about the facts. Yeah, you're free to ask questions. Feel free to have your questions. I'm going to get to them at the end of the conversation. It's a free platform for all of you, so you are also more than welcome to have your opinions and views. I would just request you to be a bit responsible and sensitive and respectful. That's all. So going ahead with the conversation, Jaideep, could you tell us a bit of the background of the dispute itself?
Yes, Sonal. It is, as you know, it's almost 1,000-year history. What started off as a small local litigation is today the toast of the whole country. My purpose today is not express any opinion whatsoever. I appeared for some of the Hindu parties, but my opinions are not at all relevant in this context. I only am going to attempt to tell you about what the Supreme Court finally did, and that's in cold print. If anybody has the interest and the patience, they can read what is 1,500 pages of A4 size paper to see what has been said. The background, as I told you, is very long. This is a matter which involved the title dispute, a dispute as to who owns 1,500 square yards in the town of Ayodhya, in a place called Ramkot, which had, at the inception of all this litigation, on it a structure with a three-domed mosque in existence, which was in existence, as you know, till December 1992. But this site had religious significance for the Hindus forever, because they believed that Ram was born there and that there existed an ancient temple there at one point of time, which they felt had been demolished when the invading armies of Babur came into India. So what the court did was it split up the entire timeline into 4 parts. The first part was up to 1525, during which time the only relevant point was that the Hindus claimed that there was a 12th century structure on the land, which was a religious structure. The second period was the Mughal rule from 1525 to 1856, during which, admittedly, the mosque was constructed. As you will figure out as I go along, the evidence about this period is very sketchy, but for the fact that there was a mosque, that in living memory we have seen that mosque. Thirdly, the third period is 1856 to 1947. As you can imagine, this is the period when Awadh was first taken over by the British East India Company and then by the British government in 1861. This continued till 1947, and then we have the fourth period, which is from 1947 till the present day, where the issue is relatable to the legal structure under the Indian Constitution. Now, a lot of the materials which became available in the course of the evidence is almost unknown to the general public. And it is very interesting to trace that history, because all that you have heard in the press and in the public uh, platforms is that we are rectifying a 500-year-old wrong. And you'll be surprised to know that that is precisely what the judgment refused to do. The judgment says that a legal system has to apply the law that prevails in the country at a particular point of time. It is no part of its job to reverse history, even if it is wrong. If a wrong has been committed in the past, then it stays in the past unless there is some provision of law in the present time which allows us to revisit that. Not much was known about this site till about 1856, when the British took over the administration of the Awadh province. When they took over, the first thing they did was actually to declare this land to be Nazul land. Nazul, in British terminology, in Indian British terminology, I should say, meant escheat, that is land which was taken over by the government from any private individuals who could have been on the land. So what the British did, because there was a live dispute on that land even then, and it is not clear that the mosque itself was a live religious institution at that point of time, but the British took over the land as Nazul land, but did not touch the religious sensibilities. That was their uniform policy in the country. They said that yes, we find that Muslims are offering prayers in this site, and we also find that the Hindus have a very strong belief that this is the birthplace of their Lord Ram. So they basically allowed both the Hindus and the Muslims to offer prayers at this site. And this we know from 1856 onwards. We don't know very much about the situation before that. Now, in a short while, this, of course, this situation did not last. And there was, in 1858 or so, there is evidence of civil disturbances and riots in this place. And so what the British did at that stage was that they created a barricade, they created a fence. And this is very important because there was the mosque, and then the British created a fence around that mosque and allowed the Hindus to continue to pray from outside that wall. It's not a wall, it was a kind of a barricade. So therefore you could actually see the mosque from outside. So it is in this area, in this outer courtyard as it is called, that the Hindus set up 2 or 3 structures. One was called the Ram Chabutra, which they felt was the spot on which Ram was actually born. There was something called a Sita Rasoi. It doesn't mean much, but whatever it was, there were a couple of structures which was built in this outer courtyard. And in these outer courtyard, the Hindus had full access. They were, in fact, at some time, they were given more than one access points by the administration. And the in this area, they were able to come into the site without any difficulty. The Muslims, on the other hand, went through the outer courtyard into the mosque and offered namaz in the mosque from time to time. Initially, there is evidence that they offered namaz regularly, that is to say, on any day. Later on, when more and more the place became troubled, they would offer namaz only on Fridays. There is evidence to show in the suits that were filed that this process continued till 1949. So independence came, and the Indian administration took over. And in 1949, what happened was that on a particular day, that is 22nd of December, in the midnight, the 50 to 60 persons, according to the court, were found to have Hindu persons were found to have entered the mosque and had installed an image of Lord Ram in his child form, that is Ram Lalla. And this, of course, immediately led to a flare-up of local trouble, which was dealt with by the administration by appointing a receiver over that land. A receiver is a court officer who takes care of it. So the court takes over possession. The magistrate concerned. Yeah,
Which year, Jaideep? What year was that?
that is in the end of 1949, December 1949.
Okay.
So the receiver at that stage, that is a court-appointed officer. Court in this context meant the magistrate of the place, was appointed, and he was told to take charge of the entire area and to keep it under his control. Interestingly, that was after this. It appears that the Muslims did not offer namaz in the site, but there were some Hindu festivals, maybe once a year or twice a year, which was permitted by the administration. This involved people gathering for festivities and all that. So this position, that is to say, a court appointed officer taking over the control of that premises, continued all along till 1992, which I'll come to in a minute. In between, what is important is that in the 50s, several civil suits were filed. Civil suits are the way you initiate any civil action in this country under the Civil Procedure Code. So some civil suits were filed between 1950 and 1961, which I shall come to in a minute. But to conclude the sequence of events, in 1992, as you know, on 6th of December 1992, there was an event in Ayodhya where the structure was brought down by a group of people, and this was followed actually by legislation. By the government legislated at that point of time, this time appointing what is called a statutory receiver by way of a statute to take over temporarily till the final disposal of all the matters, the entire premises. And since then it has been it was under the control of the statutory receiver under the legislation itself. So this, and then finally, of course, two things happened. The matters did come up for hearing after all the evidence was taken before the Allahabad High Court. The Allahabad High Court held that three groups had joint possession of this land for the known period. One was the Muslims, one was the Hindus, and the third was a Hindu Akhada, a particular Hindu organization called Nirmohi Akhada. And they said these three parties were all jointly in possession of the land, and so proposed a three-way division of the land between these three organizations. Then the matter, of course, came to the Supreme Court, and in December last year or November last year, it was decided after a very long hearing, one of the longest hearings that the Supreme Court has actually had. And at the end of it, we had the judgment, which, as I told you, is 1500 pages. And the judgment held ultimately, and I'll go into the issues later on, but it held ultimately that no, this is one plot of land, one piece of land. It can't be split up on what is known in law as balance of probabilities, which is not a terminology that I wish to discuss in today's talk because it's a very complicated legal proposition. But on a balance of probabilities, the Hindus had possession of this land during the British period up to now, and therefore they should be permitted to utilize that land. But because there was an event which brought down the mosque in 1992, therefore, um, to balance the equities, if I may say, that's not the language which is used in the judgment, but to make things right, if I may put it that way, uh, uh, 5 acres of land, which is 5 acres of land, which is bigger than where the mosque was actually situated. 5 acres of land would be given to the Muslims to utilize as per their wishes in the city of Ayodhya. So that's where we are, and that ultimately led to the show that you all saw on the 5th of August. That's the background, and that's a very, very short summary of about 1,000 years.
So, what was the nature of the dispute in front of the court, and how did it get there? Like, how did the dispute even started and get to the court?
Right. So, you see, the dispute comes to court only in 1949 when overnight the idol of Ramlala was installed in the mosque. And there were initially uh, four proceedings which started. On 5th of December, and I'm giving you the dates because it's a little relevant and interesting.
So,
On
so
5th of December 19,
just for my understanding, that dispute actually started in 1949 itself, which continued, or
yes,
oh, okay,
yeah, it continued. Yeah. Dispute started then, and the legal proceedings also started then in response to that
19,
particular dispute.
okay, and that is the decision that we got this November. Uh,
That is the decision you got in November 2020. The whole thing took 70 years to in the courts. It went through the courts. It was filed in the lowest court. It went to the High Court. Then it went to the Supreme Court. And of course, the evidence, as you know, is always taken in the lowest court. And the High Court, uh, in this case, of, I don't want to get into those details. As a matter of fact, in the process of various legal proceedings, the High Court was asked to dispose of these suits as if they are fresh suits filed before the High Court. It should have been done in the lowest court, but it didn't matter. The High Court was told to dispose of. And the first appeal, those amongst the audience who are lawyers would, of course, recognize that the first appeal went to the Supreme Court. Normally, what one would call the third or the fourth appeal goes to the Supreme Court. In this case, the first appeal went to the Supreme Court. The significance of it being a first appeal is that the Supreme Court normally does not interfere in factual findings, but in fact, it confines itself only to questions of law and takes the findings of the lower court in the first appeal as the final finding of fact. But as far as this case is concerned, the Supreme Court took it as a first appeal. Therefore, it actually did go into the evidence, and it took decisions on facts which were contrary to what the High Court had decided. Now, there were four such proceedings, as I was telling you, to start with. So, in December 1950, first of all, one of the priests of Ayodhya, his name was Ramchandra Das, and he went before the civil judge of Faizabad, which is the district concerned, and he sought certain reliefs. Uh, I should correct myself a little bit. The first of the suits was filed by a Hindu devotee. His name was Gopal Singh Visharad, and he filed in January of 1950. He said that he was being prevented by officials, that is government officials, from entering into the inner courtyard of the site to offer worship. And he asked the court to give him a decree that he is entitled to access the inner courtyard freely. So this was the first one, and this was by a person called Gopal Singh Vishadad, who said that he was a Hindu devotee. There was a second suit by Ramachandra Das, who was a priest, but that suit got withdrawn at some stage. In 1959, that Nirmohi Akhada, who I mentioned, who have been active in that area, particularly in and about the mosque, they also filed a similar suit saying that they were the Shebayats of that temple. So the concept of a Shebayat is somebody who looks after the idol. An idol is a legal person, but of course the idol cannot act on its own. So therefore, some actual human being or a human organization must look after the idol. And the Shebayat is the concept that we have in Hindu law and in Indian law to describe a person who takes care of the idol. So the Nirmohi Akhada confined its case to saying that they were the Shebayats. Then we had in 1961, and this came very late, as you can see, 1949 to 1961, there was no proceedings instituted by the Muslims. So in 1961, the Sunni Waqf Board came to court and said that the land belonged to them, because this was a waqf and therefore the land belonged to them. They gave 2 or 3 justifications to show that the land belonged to them, and and they wanted to be the court to declare that the entire disputed site was a public mosque and the delivery of possession should be given to them by removing the idols who had been installed there. Now, it didn't stop there. You see, these are the original proceedings. But there is one very important proceedings which ultimately becomes the kingpin, if I may say. In 1989, the most important suit was filed, and this suit was filed in the name of the idol itself. So the first party of that suit is Ram Lalla, the idol itself.
Oh,
That is permissible. Yes, that is permissible in law. The deity can file a suit, but the deity can file a suit. In order for a deity to file a suit, obviously a human entity has to come to court.
correct.
So the law that is developed over the decades, or even longer than that, is that the first person who can represent an idol is a Shebayat. And if you can't find a Shebayat, suppose there is no Shebayat, in that case, anybody who is interested in the idol can come forward, and he is called the next friend. He is called the next friend. And so therefore, a next friend instituted a suit, A, in the name of the idol, and B, there was a second party there, saying that the Janmasthan itself is a legal entity. That is, the land itself is a legal entity.
Okay.
This was a very innovative concept, and it is an innovative concept because it was based on the theory that in Hindu law, and this is regular Hindu law, a temple can be consecrated by somebody, and then the land becomes a temple, or some land or some any land actually could be by itself holy. By itself, it could be sacred, which was what they claimed for this, and this is the word used for it is Swayambhu. So the word is that this land by itself is sacred, and therefore it also, you don't actually need to consecrate a temple there. You consecrate consecration means somebody actually goes there and does what is known as a pratishta. But here we are talking about a situation where the land itself, for spiritual reasons, is sacred, and therefore it is Swayambhu, and nobody needs to even set up a temple there. Reason why that was brought in is not relevant just now, because the court didn't accept the second plaintiff. They said, no, we are not going to hold that any plot of land can be can itself file the suit because it's Swayambhu. They gave an explanation. But they did accept that yes, Ram Lalla through a next friend can certainly file the suit. And there what they
Who
said
was
was,
in this case?
the next friend was an individual from Ayodhya. His name was uh, some Agarwal was his friend. Agarwal is no longer actually alive. He was replaced by somebody else when he passed away. But the fact
Yes.
is that he was also a plaintiff, and the Ramlalla was the plaintiff. This suit said that it has been under this, it has been under the court receiver for so many years. Give it back to us. That was basically the idea. So this gives you these five suits, of which one ultimately got withdrawn. These five suits ultimately came all the way through the High Court to the Supreme Court and were decided in the final judgment. So that's the nature of the dispute, and that is how the matter actually reaches court.
Okay. One thing that I'm very curious to find out, and which is not, I think, easily available for us, what are some of the overriding principles that the court based its decision on? It was a huge verdict, so there must be
Yes,
some core principles out of which the judgment came about, right? Could you shed some
yes.
light on those principles?
No, there indeed is. It is a very important judgment, and it is certainly had some very important principles laid down in it. But what I think needs to be communicated to the general public, and of course, it is not usually done because we are not usually having a legal discussion on television. Despite the fact that this judgment is of enormous importance to a large number of people of both communities placed on the different sides of the dispute, and it was their beliefs and faith is so fundamentally involved. The court did not decide it on the basis of their faith at all. They did not decide it on the basis that there was a Hindu temple, that it was broken down by Babar or somebody on his behalf. The contention was that one of his generals was asked to go and break it down. And therefore, we are restoring to the Hindus something which had been wrongfully taken away from them. This principle has not been applied at all in this judgment. The judgment says in so many words that we cannot do that. We cannot question historical acts, and we cannot decide whether a historical event was valid, invalid, right or wrong, whatever. So they said we are going to look at it purely as a property dispute. It is as if you and your neighbor had a fight, saying that this piece of land belongs to me. And what would be the legal principles which would be applied to decide such a question? And we are going to apply only those aspects in order to decide this dispute. So, property, what is the title? Who has the title to this land? So, we are not going to go into the question as to who had title in the 12th century. We are not going to go into the question as to whether their title was taken away rightfully or wrongly. We are going to go into the question as to what is the position today, who has been able to prove, because mind you, in any civil suit, the date on which the decree is sought is the date which is relevant. So in this case, who was it who can claims to own the property in 1951 or 4951, round about that time? So they primarily applied principles of property law in order to come to this conclusion. That's number one. Number two is that when they tried to apply property law, they said that the first thing we are looking for is evidence of title. Because if you own a piece of land, you usually have a document to show that I have purchased it from somebody, or this is how the land has come to me, and I'm the owner of this land. When they entered into that exercise, the Hindus said we have title from the 12th century. The Muslims said no, we have been offering, it is a public mosque, it's a waqf, We have been offering prayers here um, from about at least from the 15th century or the 16th century, and they both claim title to the property. The court found, and this is to my mind a very important aspect of the matter. The court found that the evidence did not show title in anybody. It did not show that the Hindus had title or the Muslims had title, because you see, anything can be, there can be historical theories, there can be academic theories, but when you come to a court of law, you need evidence. Everybody knows that distinction. If I give a slightly facetious example, when you read a detective novel and a policeman is working out a mystery, he finally works it out and says that this is what has happened. But you'll always see him saying that, but I won't be able to prove this in court unless I have evidence. So the important thing becomes the court had to be given evidence. That's the court's job. You can have a historical theory, but the court cannot act on historical theory. So it says, give me evidence. It said, I am unable to find evidence of title either in the Hindus or Muslims. Then it went on to say that whenever we cannot find ownership, title, evidence, we look at the next best thing, which is possession. So again, to take a common analogy, you are living in a house. Somebody comes and says, do you have title? You say that I am unable to show how I have title. But look, I am in possession. I have been here for the last 10 years. And if nobody comes forward with a better title than you, then your possession is enough. I'm simplifying this logic in complete layman's terms. So having found that neither the Hindus nor the Muslims have been able to prove their title over the land, the court said, all right, we will now look at possession. And when they looked at possession, they said, and this is because of all the material that I was discussing when I was talking about the background, they said that at least from the British times, we have evidence that uh, prayers were being offered by the Muslims, but the possession of the site was primarily with the Hindus. And one of the most important aspects that they have focused on repeatedly is that the outer courtyard was in the possession of the Hindus. Now, the person who is in possession of the outer courtyard, admittedly, that regarding that there was no dispute. There was no dispute that the outer courtyard was in the possession of the Hindus. They said that the outer courtyard is undoubtedly in the possession of the Hindus, so therefore they can control who is coming in and going out from the. Therefore, taking everything together, which is called preponderance of probabilities in a civil case, taking everything together, we come to the conclusion that the possession is with the Hindus. And they made it clear that they can declare possession only if the current law allows them to declare possession. So they cannot declare possession based on what happened in the 12th century, because there was a subsequent empire, Mughal Empire, which had its own laws. Unless it was shown that the Mughals allowed the Hindus to continue to own that land, during the Mughal period, it would be the title would not remain with the Hindus. Similarly, when the British took over, then also what did they do? Did they allow people to retain whatever they had, or did they make changes? The only transition that we actually have a full legal framework for is the transition from the British to the to independent India, because that is governed by the Indian Constitution. The Indian Constitution says whoever had whatever rights prior to the independence will continue to have. So primarily we are concerned with the evidence as it developed in the British times, and that remains the right, and that right is being given to the Hindus. But because of the fact that that there was a mosque, the mosque was destroyed, may not be in a valid manner. The court could not actually decide that question, because there are criminal proceedings still pending against people who had demolished the mosque. They said that for that we apply other principles of law which allows us to compensate the Muslims and give them 5 acres of land to do whatever they wish to do. So this is, to my mind, the overriding principle, and by which the court has sought to resolve this dispute. Because, mind you, the court is not unmindful. Never are they unmindful of the fact that that it is dealing with a social issue also in these situations. But now
We have a
I'm coming dangerously close to opinion, so therefore I'll stop there.
we have a question from Radhika Ghai. She's asking, are there any other pending lawsuits that could impact this decision in the future?
No, none. The court made it their job to bring this dispute to a complete end at this point of time. Now, I must, of course, tell you that there are various legal ways in which disputes can be revived in future, but the chances of it happening is almost zero, because the most important way in which it is revived is a review petition. That review petition has been filed, it has been dismissed by the Supreme Court. So
Okay.
unless some new evidence is found in future and somebody actually starts a new proceedings, it's not this question is finally ended here. I must tell you that the criminal proceedings haven't ended. So the people who brought the structure down are still facing criminal trial in courts in UP at this point of time. But there are no pending civil cases, no.
Okay. And what were the precise conclusions of the court?
So I think I have more or less actually covered it in what I have said so far. The precise conclusion, and actually I really want this to be clear to people. One of the things that it has said is that legal consequences of previous regimes can only be enforced to the extent it receives express or implied recognition by subsequent sovereigns. Courts cannot compel subsequent sovereign to recognize or remedy what is perceived to be a historical wrong. It is absolutely necessary that people understand that it has not been held that this was a Hindu temple which has been demolished by a Muslim ruler, and now we are rectifying that wrong. That's a sentiment. That is the sentiment of let us say, a large body of Hindus. But that is not a legal determination. It's not a court's finding. That's one. Number two is that why did they fail to establish that in the 12th century there was a temple there? Because the only evidence that they found that they could present to court was an archaeological survey report. The archaeological survey went there and dug below the surface and came out with their report. And the finding of the archaeological survey is interesting. They say that they found that there was a 12th century Hindu structure underneath the mosque. It was in existence. On the structure, on the walls of this structure, the walls of the mosque has been built. That was found. But why is this not enough? This is very important. It is not enough because ASI report cannot prove that the earlier structure was there till which date. There is a gap, you see, of 400 years between the so-called temple and the arrival of Babur in India. Now, when did this structure come down? In 400 years, any structure can become ruins. So they said that the ASI cannot prove that the earlier structure was demolished for the purpose of construction of a mosque. They could not prove that. They could also, in fact, they found evidence to show that it is not true to say that the ruins of a temple was used to construct the mosque, because the mosque was constructed with a stone which was not the stone found in the foundations. So they said that even though we find that the construction had been made on the foundations of the old structure. This does not prove the case that there was a temple there all the way till Babur came, that Babur was responsible for destroying that temple, and that he built a mosque on that structure using the materials which were in the temple. Now, mind you, it is, of course, I should not go into it again because we are talking only about the judgment. Even Delhiites are aware that ruins of older temples have been used to, uh, older Hindu and Jain temples have been used to create mosques. That you will see it in, it's quite apparent in the Qutub Minar, in the Qutub Mosque, the Kawatul Islam Mosque in Qutub. But that is not itself a problem. You see, the Romans found Greek ruins, and those Greek stones were used to construct their own structures. That's not wrong. The question was that can you prove that from 12th century onwards the title was with the Hindus? And they said this ASI report will not be enough to prove that. So that's the second thing which is very important. The third thing was that they said that the Waqf also, the Sunni Waqf board, did not have evidence to show, apart from the fact that there was a mosque on the site, they did not have evidence to show that prayers were being offered there till 1856. The evidence of the Sunni Waqf board, and they admitted, they had said, yes, that is true. We don't have evidence to give to a court of law that there was prayers being offered, namaz being offered prior to 1856. After 1856, because of British record keeping, there was evidence of namaz being offered all the way up to 1949 when they were dispossessed from the mosque. So this is the third thing. The Nirmohi Akhada's case completely failed because they said that it was too late for the Nirmohi Akhada to go to court in 1961 for being thrown out of the temple, which is what they were claiming in 1949. But then Nirmohi Akhada's contribution and involvement in this whole thing, they acknowledged by saying that when you constitute a trust, and that I'm going to come to that in a minute, when you constitute a trust, you should have a Nirmohi Akhada man in that trust so that they still have some say in the matter. So having come to this conclusion, it then says that, you see, these are religious groups. A single individual, that next friend, could not have looked after Ramlalla or built anything there, nothing of the sort possible. So the court said, you set up a trust. Now, it's important to remember that under the Indian constitution, which is a secular constitution, the government cannot itself participate in either the setting up or the administration of a religious institution. So therefore, whenever the question of administration of a religious institution comes up, it has been the practice in this country since independence to say that an independent trust or a statutory body like the Travancore Devaswam Board in Kerala, or sometimes the temple itself, a statute is passed creating the administration of a temple. That has happened in hundreds of temples in India, big ones, the really important temples in this country. They are all governed by their own statutes. So you create a trust. The trust will thereafter think about how it wishes to go about what to do with the site, etc. So these are some of the main conclusions which were drawn by the court.
I don't see any more questions from the audience. I have one which is not relevant to today's conversation, and it's not the law, but any timelines on when the temple will be done?
Not as far as the court is concerned. There are no timelines. There was a timeline as to when the land has to be given to the Muslims. The timeline said that it has to happen simultaneously. You cannot do anything with your land until and unless you have ensured that in accordance with the decree, land has been made available to the Muslims. That has already been done. In fact, there has been a land allotted. Yes, land has been allotted. the council for the one of the councils for the Sunni Waqf board had said that this is not in accordance with the order. It is not within the city limits of Ayodhya, as the court had said. But it seems to me that the body which is going to look after that land has accepted it. So we I think at this point of time there is no dispute.
Okay. Well, since I don't see any more questions, I think that was a very informative session, Jaideep, because mostly what happens is whenever we see a judgment, like you said, we make our assumption based on our sentiments and not the facts.
Yes,
A lot of times the facts are completely hidden. So
yes,
that was the whole point of you bringing on the facts on the table, because I was also not personally aware that the one of the principles that the court actually used was the possession, because obviously they couldn't have proved anything beyond before
yes.
possession, right?
They were unable to, yes.
They,
If you have a minute, I wanted to add one thing.
please.
This is not central, it is not central to the case for the resolution of the dispute. But the court did go into it. And it said that, by the way, it's like a by the way. In 1991, something called the Places of Worship Act has come in. The government has legislated. The government has legislated saying that in future, any religious site, uh, the government will have a positive obligation to maintain the religious character of every place of worship as it was on 15th of August 1947.
Okay.
So in 1991, they have passed a legislation which says that you will not change the religious character of any place of worship from the status that it had in 1947.
Okay.
But this is a by the way point, because when they legislated in 1991, they were fully conscious of the existence of the Ayodhya dispute, the Ram Janmabhoomi dispute, and therefore they said that this act does not cover the Ram Janmabhoomi dispute. So therefore, as far as Ram Janmabhoomi is concerned, this principle is not applicable. But they made it a point to deal with this principle in the judgment, which the significance of it is that every time this question now comes up, the question will be what was the status of the land in 1947, and no change can be brought about as far as the religious significance of that land is concerned once you find that this land was used in a particular manner in 1947.
I guess this will also help for the if there is any
If
future
there is further
dispute.
dispute, yes.
So I think that's also good to know, because
Uh,
they wouldn't have to dig into what we had to for this
yeah,
judgment.
yeah.
Yeah.
Hopefully, no more 70-year disputes.
Right, no more 70-year disputes. So, well, if there are any questions, this is the time. Otherwise, thanks again, Jaideep. That was a very, very informative session for most of us. And no, there's no questions. Thank you again, and thanks for being on the show, and thanks for picking up the topic that was so relevant and current and disputed. But actually, you did wonderful job of just staying with the facts, with the law, and at the same time giving us enough information to take this ahead. I'll see you on this Thursday on the Blue Mug chat. Thank you all for being here. Thanks for joining on a Sunday evening. Till next Thursday, this is Jess Sonal signing off. Thank you, Jaideep. Bye.
Thank you very much.